like I said, my name is Jim Smith, and I'm an attorney and the co-owner of Indiana Title, and we have offices here in Muncie and in Newcastle. And I have been in the title business since 1988. When I wrote that and started thinking about how many years, it kind of freaked me out a little bit because I thought, man, has it really been 37 years? Time flies. But as we've already indicated, the talk I'm giving today is on heirs property, is one way to say it, and also known as tangled titles. And when they told me that was it, I'd never heard the term tangled titles. But let me tell you, I've lived it for the last 37 years. I mean, and I just have had time after time. I mean, our office is close to the courthouse, and a lot of times people will go in to the auditor's office and say, hey, I'm trying to get this property in my name. They send them over. My partner and I are attorneys. They send them over. We often can help the people, but sometimes it really gets tough, and sometimes it's beyond anything we can do. Anyway, I'd never heard tangled titles before. So, like Nate said earlier, if any time, there's all different kinds of people in here as far as their professions. And so if I am going too fast, or if you have a question or need a statutory cite or something like that, just stop me. I want to make this real casual and informative, hopefully. So again, as we've already discussed, the problem that we're going to addressing today is when someone owns a piece of property and they are deceased, and it's not been properly transferred to their heirs, devisees, or whoever should, whichever should get the property. And often people come into my office and say they're the ones that should be getting it, and after I research it, it's like, sorry, it's not that way. And we'll get into that a little bit later. That's not what the statute says. And boy, people get angry, and it's, I say, don't kill the messenger. I'm just reading the statute and telling you what's what. So the first thing I wanted to talk about a little bit as a way to get into my conversation is explaining in Indiana the different ways individuals can hold title to real estate. And that's, it's really important because we have to look at the deed, affidavit, the estate work that's been recorded to determine exactly how title is held. And a lot of times people come in and it's not the way they think it's held. So it's very important if any of us are helping people get their property ready to be transferred upon their death. And that's always a tough thing to talk to people about. Myself, with my family, it's like you just don't want to bring up mom's going to be gone someday. You want to just kick it down the road. But it's so important to look at those things and work on that prior to the passing, if you can, so it can get set up the way you want to have it set up. So anyway, it's and to review the title and see how title's held, that's important prior to their passing to try to set up a good transfer mechanism. Or if they didn't have anything, you have to look at it and see, because sometimes I've had several occasions where people were all worried, and it turns out there was a survivorship clause in the deed that it transferred to them anyway. They thought they'd have to go through some kind of estate proceeding. And by the way, what we do at our office, we do minor estate work. Like if we don't do courtroom work, we don't probate wills, things like that, but we can prepare affidavits for simple transactions to saves people a lot of money rather than having to go through an estate proceeding. Don't tell any of my brethren attorneys that I said that. The first way that I want to talk about that people can hold title, and I'm talking about individuals mainly. I'm not going to talk about entities too much, a little bit later, but the first one is married couples can hold as tenants by the entireties. And that's if spouses take title when they're married, that whether it says as husband and wife or husband and husband, whatever, it's presumed that that's the way they take title because it's got a lot of benefits under the law. So the statutes have made a presumption on how if a married couple would want to take title most of the time. Now they can take title in the other manners I'm going to talk about, and occasionally I see that it's usually for some kind of estate planning purposes, and usually with big estates. But anyway, so what happens is if they are husband and wife, and one of them passes, it automatically vests in the other one totally. That's an operation of law. All we do is file an affidavit indicating that they took title as husband and wife, and that they were husband and wife when they passed, and it just automatically goes to the survivor. Now, a couple problems I've had with that I wanted to point out, and if any of you are helping people with this, I've had a lot of cases where, X and Y aren't married, and then they get married. They think that's all there is. That's not the case. You have to file a deed. So if you took title as one of the other ways, tenants in common or joint tenants, as I'll talk about in a minute, and they did not deed it after they were married from themselves to themselves, they hold in the old way. They don't hold as husband and wife. And I've had some terrible, people basically crying in my office like, I didn't know we had to do that. I thought we held as husband and wife. No. So if they took title just in their name, yeah.
Yeah, you say they were married, but one had bad credit, and the person in the house or property under one good credit, so they didn't have to deed it all, correct? But if that person that purchased it passes, it goes to the state. Is that what you're saying?
So if it's just in the individual's name, and I see that a lot, where people, for their lender, they can't take title as husband and wife, so it's just in the wife's or one of the spouse's names, then they hold individually, and if that person passes, then it's going to be either go through their will or intestate succession, which we'll talk about in a little bit. What I see happen a lot of times, they get their loan under just one name, and then they deed it to each other, or the one deeds it to both of them as husband and wife, or husband and husband, or wife and wife, whatever. After the mortgage is made and the note has been executed and the mortgage made, and I think that's important because let's say Annette and I are married, and my bad credit, they have to put it in her name. Then she deeds it to her and I as husband and wife, and we're husband and wife. My bad, like if I've got judgments, tax liens, they don't attach to the property. That's one of the special protections that husbands and wives get. The bad things that I've done or that I have on my credit don't apply to that because it's a special way under the law that protects that marital property. Okay? Does that answer your question?
Go back and add the person's deed to protect them.
Yeah. And we.
They don't have to be on the mortgage, but you can add them to the deed after closing, and sometimes the lender will let them be on the deed at closing.
Yeah.
But they're not on the actual mortgage if they haven't had a job for long, whatever.
Right.
But then the protection is there, and I think that situation of not adding a person causes a lot of issues.
It does.
Because you have, I'm a realtor, so I say sometimes. I don't know you're not. I know you are.
A very good realtor, I'll say.
But this happens all the time where I had a client in particular, it was only his wife's name and she died, and he paid that house off, and I was like, you don't own this. And then the kids were like, you want the house.
Yeah.
But he was never on it, and they should have added it to the
Right, and we'll get into some of the problems with that later. But and a lot of lenders now, they will, like Rebecca said, they will let you just one of the spouses be on the note and then they'll just have they'll allow them to own jointly and have them both sign the mortgage. They both have to sign the mortgage, but they're not on the financial part of it. So.
But even if they won't let you, you can go back.
Right.
After that's initially recorded, you can go back and do a new deed where this person signs it to the two of them together, and then that person is on the property.
Yep. Yep.
Really basic question, I should probably know more than I do, but, so, if, somebody dies, and they haven't done anything, no planning, what happens, that property goes to,
We'll get into that pretty heavily. Yeah, I tried to put this together, and I thought, what's the right order? Because the real meat of what we're going to talk about is that later, but I wanted to talk about these things first. But that's a great question.
Wait, I got one question regarding what she said with the deed. She says that the wife died, the husband was paying the mortgage, and the kids wanted the property. So did that cause a problem, or because of that, or?
Yes.
Because she.
So it was her kids, which doesn't matter, but he was not on the deed. He had lived there for 15 years with her, or whatever. She passed away. He had a small balance left, $5,000 or whatever. I mean, he had paid on it the whole time. They were living as a couple. He paid the property off, so he's just living there. And then the kids were like, "No, we want the house. It's ours." And he had no rights. I mean, I don't really know what ended up happening with him, but he had to get an attorney and stuff because it's not his house.
And there's a lot of factors we'll talk about to who would be entitled to the actual house. But I've ran into that a bunch where not just a spouse, but kids will make the mortgage payment and pay it off and then find out it doesn't go to just them. And then they've got some step brothers that want to hold them up, and say, okay, I'll deed my interest to you, but I want this much money.
Unless there's a will?
Yes, and we'll get to that. Yeah, yeah. If there's a will, there's some things that you have to do to make a will valid. We'll talk about those in a second.
Because I'm having that same problem in the family right now.
Yeah, yeah. So we talked about tenants by the entireties. The next way to hold title in Indiana is what's called tenants in common, and where two or more people take title, and it either says tenants in common or it doesn't say anything at all. The law presumes, and they're not married. The law presumes they take as tenants in common, and like I said, a husband and wife can take in that manner. Normally they don't, except in very specific circumstances. So if there's a deed to me and my wife Annette and Rebecca, we hold as husband and wife for our part, and Rebecca holds as tenants in common, with us as tenants in common. So, but the thing to remember there is if you hold as tenants in common and heirs take in that manner, that's something we'll get to later, but the heirs take title as tenants in common. If one of them passes, it does not automatically go to the others. It goes to their heirs or devisees. Either their will, or if they don't have a will, a valid will, it goes to we'll get to intestate succession later. And that's where I see a lot of problems. 4 people on title, 2 of them are passed, and they don't have estates, they don't have wills, and each has several kids. Their fourth interest goes to their kids or their grandkids, and we'll talk about how it goes, but you can get a huge number of people that have to be involved to clear it up. I've got that here, yeah. That is true. Which I am shocked at how often they can get things signed and notarized. I don't know what the process is, but you're going to have him or her sign, and they come back later and they've had it signed and notarized. So then, excuse me. So the third way, and it's called taking title as joint tenants with right of survivorship. To take individuals to take title in that manner, it has to say it or say something that is deemed to be that in the deed. So again, Annette and I, we take title as joint tenants and right of survivorship. We get some of the protections of what, like a husband and wife. The main thing is if I pass, it goes automatically to Annette, and she gets, all she has to do is file an affidavit saying that, you know, I passed and we remain joint tenants, and it's a real simple process. And so, and I've had people come in and, you know, in the Annette's shoes and say, this guy that I used to like, he's dead now, but we didn't help, you know, I don't know what to do about his half. And I look and they took title as joint tenants. I say, you're good. It goes to you automatically. So sometimes there's happy endings when these people come in.
Excuse me, Jim.
Yeah.
So can you explain, like, is there, so you have to declare when you're doing the deed, the type of,
Yes and no. There are legal presumptions. So if two people are married and it's deeded to them, they are deemed to hold as tenants by the entirety, unless the deed specifically indicates something different. If two people that aren't married are deeded property and it doesn't say anything, they are deemed to hold as tenants in common, not as joint tenants. To hold as joint tenants, it has to say joint tenants. I mean, there's a lot of different language that has been held by the courts to satisfy the requirement, but basically it has to be very clear that the intent was they'd hold jointly and that it would have this survivorship right. Okay? Okay. So I want to, as if I haven't already digressed with some of the stuff here, but I want to digress and talk about a few transfer options that I see used. Doesn't really apply very much to what I think we're talking about today with properties that have tangled titles. And that is where somebody sets up a trust and deeds their property to the trust, or sets up a corporation, partnership, LLC, and deeds it to that. Those have, once the principles have passed, there's a continuity, and like for a trust, as long as it was deeded and recorded to one of those entities, it goes to however the trust reads. The problem with that, it's a great tool, but it's expensive to set up a trust, and it's there's some burdensome problems with with administration of it. I'm sorry, I lost my place. It's a great tool for bigger estates, and I see it used mainly. But I have had cases where people come in, sometimes in fairly decent sized estates, and say, well, I need this trust to deed it to who's supposed to get it on the trust. And I look, never deeded to the trust. They created a trust, but you have to go the next step. And a lot of these things I'm talking about, you have to make sure it's properly recorded, the deed, in order for it to be effective. Okay? And there's a whole law on how transfers occur. Like an example is if I make a deed to my kids, but I don't want them to have any interest in it, and I just put it in a shoebox and say, hey, go get that and record it after I die. That's not a valid transfer. It has to be transferred while I'm alive. And the same thing kind of holds true for if it's deeded to a corporation. We have that happen all the time. These closely held corporations, you know, it's in the title, and somebody comes in and say, well, I'm the owner of that because my dad, you know, I'm the only heir or whatever. Well, I'm sorry, you're not the owner. It's owned by the corporation. So we have to figure out how the corporation can, who's got authority to deed it to whoever's supposed to get it. Okay?
Real quick, I got a question.
Sure.
Right now, I got a call today about a neighbor who has an issue with a tree from a empty vacant house right now. What she found out is that the property is titled in a, not a will, but a, what they said was in a trust. And I guess the family is fighting over the property. So the property is being neglected.
Well, the trustees of the trust should be handling it, but I see a lot of times where they won't. And then what happens is, and as we've dealt with, Rebecca and I, there'll be weedlings or different types of, the building gets run down, so there's orders to board, things like that. And it just hurts the principle of the trust if they don't deal with that, because then you get these big fines and things. So
Is the trust the bank or?
it could be a bank. You'd have to look at the terms of the trust, and sometimes the deeds will say who the trustees are. But like, for instance, if it's deeded to me as trustee of my trust and I'm deceased, then you have to actually look at the trust to see, are my kids now the trustees? Is my wife the trustee? Or is now the bank going to, because there'll be a hierarchy of, if I pass, who becomes the trustee. And those usually aren't public records, so unless you can get one of the kids to show you the trust, which we have to a lot of times. If you want us to do anything, we need a copy of the trust. But a neighbor, they may say, sorry, I'm not divulging that. So then there's not a whole lot that you can.
Because it's changed hands a couple of times. And it's like what Nate was saying, like there's a woman that owned the property and she died, and now it's got to sit until it's the tax sale, is that what you said? But this is, I don't know if this is a tax sale or not, because the property has sat for several years. So obviously somebody is doing the upkeep on the tax part, but the property itself is horrible. I mean, the grass, not the
Yeah.
grass, but now it's been tagged by the city to cut the grass. They had to cut the grass, the overgrown trees. The front door stays open, so squatters has been in and out of there, so the property is not being taken care of, but it's tied up in this trust.
Yeah.
And the thing is, I don't know why they haven't moved on getting this resolved.
And that's kind of the same kind of deal we're going to talk about here, the tangled heirs, because it may be that the trustees are both dead, whoever was named didn't want to do it, and then trying to figure out who has the authority. Sometimes it takes a court action to determine who should be trustee of that trust. But a lot of times it's just what you said. People won't pay taxes, and it'll go into tax sale, and they'll lose it, and it'll go to whoever buys it at tax sale. We were just talking about one with his grandpa that is still in his grandpa's name, and somebody's paying the taxes, and it's coming to my office, or it did, and we don't know who's paying the taxes, because I used to work with his grandpa, so, yeah. So it's not me, I swear. Yeah. So another quick aside that before we get into the meat of the discussion, I want to discuss powers of attorney. They can be, if they're done properly and have all the legalities under Indiana law, they can be great tools for transfers of the property before the owner dies. But I do want, this is something that has people come to my office and they just didn't understand and they get angry, is upon the death of the principal to the power of attorney, powers of attorneys can't be used anymore. They become invalid. They cease to operate. There was a new statute just in this session that there may be a couple little bitty things that a power of attorney can do after the decedent dies, but nothing to do with real estate or anything like that. So, I've had people come to my office. I want to use this power of attorney. My grandpa died, and I'm the power of attorney. I want to deed it to me or my kids or whatever. Sorry, you can't do that. If you are dealing with people that do have a power of attorney and they may use it, especially if their mom or whatever brother become incapacitated, you want to make sure that it's a good power of attorney and that it meets all the requirements under Indiana law, because I've had them come in and say, here's my power of attorney, and it doesn't have everything that's needed, and then you can't use it. And now's when they need to use it because their mom is incapacitated and they want to get it out of her name to sell it or whatever, and then I'm sorry, you can't use that. And so it's a good device, especially to have when somebody is getting older, or just in general, but you want to make sure it's done right, okay? Okay, now I'll finally get into the meat of it. You know, everybody would be happy if there was the property owned by the decedent went to the party it was supposed to go to in an easy and cost-effective manner. You know, that's when the prior planning really becomes important. You know, that what happens if that doesn't occur is kind of several things we've been talking about. You have a property that's in a decedent's name, and you try to figure out how to get it into who thinks they own it or who owns it under the statute or under the will, and that can be a real nightmare, especially the longer you wait to try to fix it. You know, and I've had some. Well, my grandma and grandpa owned this, and they died in the 70s, and I'm like, oh my gosh, and I'll talk about that in a little bit, but to try to figure out who really becomes the owner can be just a nightmare. And the problem is, and I think this really ties in with the real thing that Nate wanted me to talk about, is then these properties become like she was saying, no one's taking care of them. They get overgrown. The houses, if there's a house, it becomes falling down, and leads to blighted properties, and then, you know, a lot of times it's just until it goes through a tax sale before something can be done. Okay, so when someone comes to me and indicates they want their real estate transferred to them or someone else, and it's titled in a decedent, the first thing, as I said earlier, what I do is I review the deeds and the chain of title or the affidavits to see who I think owned it at the, you know, was it really who they think, the decedent? And sometimes, like I said, I found where joint tenants and the joint tenant is still alive, and I'm, hey, you're good. It goes to them, and we don't have to do anything further to figure out who becomes the owner. And so then once I figure out that, yes, it's owned by X, who is the decedent, then I go through a list of questions, and it's kind of some of the things we've been talking about. I want to see is there a valid will for that person, or is there a recorded valid transfer on death deed? And I'll talk about both those a little bit later. But assuming there is not, and often with these types of properties, there is not, and the real estate would then pass pursuant to intestate succession. And the way to look at intestate succession, and I've got the statutes here, and I can go through the whole thing for you if you want, but in essence, the state of Indiana, through the legislature, has written a will for people that don't have their own will. And they presume that people would want it to go in this manner. And, you know, they've decided, hey, most people would want it to go to X, and then if X is dead, to the, you know, on down the line. And that's often not what maybe the decedent wanted, or what the people who are claiming that they own the property, what they want, and so that can become a real nightmare trying to figure out how to deal with it. And that's where the tangled titles come for. And before we get into intestate succession, which is kind of where I see most of the problems occurring, let's talk about the decedents who did leave a will, well, or a transfer on death deed, so or thought they did. A valid will must comply with the requirements under Indiana statutes, and also, and this is very important, people don't get this, they come in and say, here's my will, it gives it to me. Well, in order for a will to be valid, to transfer property, it has to be probated. And what probated, the term actually means proved, and basically what it means is it gets filed with the probate court, and the court proves it, agrees with it, and says, yes, this is now a probated will. One thing to note on that, and I get this sometimes, you're like, I don't want to go through all the expense. That's too much, for a X value property. Well, in order for a will to be proved, you don't have to open a full-blown estate. You can, maybe you've heard this term, spread the will of record, which basically means probating it, but you don't do all the other stuff. You don't have a personal rep. You don't send out letters to creditors, all that kind of stuff, notices to creditors, and but you can. I mean, you can have that too. But if it's something where that's really the only asset, it's really tight, they can probate that will, and then by affidavit say, hey, this will was probated at cause number 18, blah blah blah, and so and so is the devotee clearly in that will, and have the property transferred in that manner without going. I mean, there's expense. I mean, it's expensive to file to probate a will. I mean, it's a couple $100 or more. I don't remember. We don't do that, but it's a lot less expensive than to have a full-blown estate. We do not probate the will, but what I do, I have some attorneys that I work with that do, and I'll say, hey, you get them to probate it and I can do the affidavit, or they may want to do the affidavit. But it really, if you get, if that's the only asset you're really worried about, it can be a lot cheaper. And especially if the time for creditors to claim an interest, there's all kinds of time limits, but after a certain amount of time, it's valid to transfer it either by intestate succession with affidavit or by will, without worrying about claims of creditors or expenses of administration, that sort of thing. Okay?
Is a will designed to keep creditors from taking it, or?
No, really the will, it's designed to carry out what the decedent wants, to give their property to the kid they like and not to the one that was not a good kid, that sort of thing.
For it to go well, it's probate and all this stuff, that's a lot of work. Just to, if, let's say that's my brother and I die, I'm like, shit, I'm right on it. Here, I want you to take my.
Well, if you want to do that,
Don't do it like a seal, situation.
yeah. If you want to do that and not go through this, the expense, I'm going to talk about transfer on death deeds, which I think are a great deal, and I'll talk to you about that. But again, it has to be done before the person dies, and it has to be recorded and things. So. Oh yeah. Yeah.
Because my dad is in the process of doing that now. He has surgery next week. See what I'm saying?
Well, we're going to talk about what might be a good thing for you here, just in the next paragraph here. If it doesn't go, even if there was a will or it's an invalid will, whatever, but it wasn't probated, or there was no will at all, it passes pursuant to intestate succession, and that's what we'll get into, and that's normally where the problems occur with these tangled titles, because usually if they thought enough to have a will, the people know they're getting it, and they've thought about who they want to have it, and they don't have a lot of the problems if it just goes to their heirs. Yeah. I don't know how many times I've had somebody come in with just a piece of paper where maybe it's even signed, but it's not a valid, it didn't follow all the things under Indiana statutes, so it's not a valid will. And that's why this next thing I'm going to talk about is important. Those are really sad situations, and I sympathize with people because it's clear, and I believe them, that that's what the decedent wanted, but the decedent has to make sure they do the legalities to have it transferred the way they want it. Okay, and often, and I see this all the time, where the people have been paying the real estate taxes who think they own it, have been taking care of the real estate, maybe adding improvements, and when I have to tell them, hey, that's not really your property, oh boy, yeah, that causes some real, it's a tough conversation to have.
With all your information, are you able to provide that to Nate, and can Nate send that information to us through email? Everything you're talking about today?
It'll be posted, you can watch the replay.
Okay.
Yeah.
Okay.
And if I'm saying the wrong thing, don't call me on that. So,
37 years, I don't think you're going to say the wrong.
a great device is this transfer on death deed that I talked about. It's not really a deed. I mean, it's called a transfer on death deed, but it's much more like a will, but it keeps you from having to go through the probating, the expenses of opening an estate possibly, or at least probating. So it's not really a deed at all. It takes effect upon the death of the decedent. So one of the good things about it is the decedent, if whoever they name as getting the property ticks them off, or they decide, oh, I want to give it to somebody else, give it to the church, whatever, they can make that change anytime. They can sell the property, they can mortgage it. It's like a will that has zero effect until they pass. And what's really important about these, and I've had this a couple times, where people had a transfer on death deed, but they didn't record it. It has to be a valid, follow the statute, and be recorded before they pass for it to be valid. So in your dad's case, if he knew he wants it to go to you, or you and your siblings, that's something that he would just need to sign this deed, and if something would happen to him, heaven forbid, it would go to whoever he, and it's a fairly
I was going to speak to that. Actually, we've done it. My sister and I, when I was 87, we just took her name off the house, but all three of our names on it, so we don't put it all the time.
Yep. Yeah, and that's something I'm going to talk about in a minute. So, for a transfer on death deed, you do what looks like a new deed, but it's not. It takes effect upon death. We'll talk about in a second the difference between doing that and actually deeding the property. Some considerations. Okay. So, like in our office, I'll just give you an example. I mean, all the offices, title companies, or attorneys probably have different, but we just, unless there's some real, like a bunch of properties or a long legal description, the cost for us doing a transfer on death deed is $75. So, I mean, that's not a lot of money, but it's not compared to opening an estate, probating a will, and all that. And plus the recording fees, because it has to be recorded to be valid. Okay. And then what happens if you have a transfer on death deed and the person that owned the property dies, all you have to do is file an affidavit saying, hey, this person died, I now become the owner. There's a few things you have to put in the affidavit, but again, it's a fairly inexpensive process to get everything transferred over into the name of who the decedent wanted. It's really a good deal, especially for these kinds of maybe these properties that there's not a lot of other assets. It's a lot cheaper than getting a will done, and
Affidavit would be like, if dad dies, I'm not speaking that, mom can file the affidavit. Is that what you're saying?
I'm sorry.
I'm saying let's say if dad dies, mom can file the affidavit
Yeah.
and just make it simple by her just filing it if she's.
Yeah, if she's not on the property and it goes to her, or if it goes to you, you can file the affidavit saying my dad died on such and such a date. Here's the transfer on death deed when it was recorded. I become the owner. You have to give them like your address for taxes and stuff like that. But that's all there is to it. It's a pretty simple process. This came about. It's always longer than I think, but the first 20 years I practiced, there wasn't like this, and now there is, and it makes it a lot easier on certain types of properties. One thing I do say,
I was just telling her, personally, we've done that as a family. My husband's mom was in hospice, and
right?
And it was kind of the last thought that she wanted my daughter, my youngest daughter, to have a home. And I can remember calling Jim, she was pretty weak and stuff, they came out to the car to do the notary and everything. And like you said, it was inexpensive and it was just so simple.
Yeah.
I mean, it was very easy.
Yeah.
Yeah, so. Only when she died. So it was Mary's house up until the time she passed, and when she passed, it went to my daughter.
I'm trying to understand what
I know what you're going to ask, and I'm getting into it right now, because that is a very valid concern that you have. Before we go into that, though, one thing I want to say: if you do that transfer on death deed, I recommend that you make sure all the decedent's assets are transfer on death. You know, you can get bank accounts set up, or you like cars, life insurance. You know, because it doesn't do a whole lot of good if you do a transfer on death deed, but there's a life insurance policy that goes to the estate. You want to make sure it goes to whoever, and just kind of go through every single asset. Because I've had people come in and are like, I can't get this car transferred, so I'm going to have to open an estate. I don't know that that's necessarily right, but people have said that, and especially if there's, you know, like I say, life insurance proceeds that made payable to the estate, then you're going to have to open an estate, and it kind of does away with having a transfer on death deed. Okay. Okay, now get to what you were going to talk about. People come into my office all the time, and they don't know really what they want. They just want to make sure they protect their kids or whatever. And so I go through the different options. You know, you can deed it to them now, and you can deed it and hold a life estate in it. You can do a transfer on death deed, and then it won't take effect until death. The thing that people struggle with, and I don't have a good answer for this, is I always say make sure you've talked to your accountant to make sure to see how the tax ramifications are. Because sometimes people come in and they've had the house for 50 years, and they bought it for $10,000 and now it's worth $200,000. Well, if they deed it to their kids now, when the kids sell it, that can be a big capital gains that they have to pay taxes on. So I say make sure you're good with that. On the other hand, and I'm not an expert, I'm not an elder law expert, but for public assistance programs, when somebody goes into a nursing home, some people come in and say, I don't care if it causes capital gains to my kids, because if I don't do this, I have to sell the house and use all that money up before I can qualify for assistance with the nursing home. And so it becomes a real struggle, which way makes most sense. And I don't have a good answer for it. I know that if they wait until they die and with a transfer on death deed or a will, or even intestate succession, you get this stepped up basis in the property. So the property they bought for $10,000 that's now worth $200,000, when the kids get it at death, it's the value then on the basis is $200,000. So if they turn around and sell it, there is no capital gains. So but it's a struggle with, do you want to wait for that if you feel that the alternative is, if you don't deed it to your kids now, you're going to lose it all with public assistance. Now, one thing I've had people come in and say that it works, I'm not saying it does, but they'll say, well, I can have a life estate in the property, I can deed it to my kids, retain a life estate. And then that life estate is not counted for public assistance. So it's a way that they can get it, out of their name and still maintain control of it. And sometimes that works best. You still would have the potential capital gains issue, but again, I'm not a tax accountant, but just telling you guys, if you talk to anybody about this, make sure you tell them to check into that, okay? And if you do, like in your case, where it was just deeded you with I think there was no life estate, it was just deeded to you and your brothers and sisters, then your mom or dad or whoever did it to you, they lose control. I mean, I've had people do that, and then they come in a year later, well, my kids are selling this, and they're wanting me out of the house. I'm like, well, you gave up control, and we kind of warned you about that. I mean, that's a lot of these things aren't the norm. Most families hopefully get along and can work together, but that's a thought. That's why a lot of times I say, well, you can hold a life estate. That way they can't kick you out of the house. But if you wanted to sell it or mortgage or anything like that, you're going to have to work with them to do that and then figure out who gets the proceeds.
We did it strictly for protection, just in case you would have to go into assisted living.
Yeah.
Or what have you. And if
Yep.
you
And
wait too long, they don't care if you waited a year.
right.
You've done for a year, so they can still come out there.
I've heard 5 years, but I don't know if that's correct. And it may be the type of assistance, but yeah, they have this look back period. So I have people coming in. My mom's getting ready to go in a nursing home tomorrow, so I need to get this out of her name. And I'm like, I can do it, but I'm not sure that's going to work. You want to check that they may be able to look back and have that set aside. And another thing, people come in and they'll want like a transfer on death deed or a deed. And I'll say, have you worked with anybody like a private attorney on estate plan? Oh, yeah, we've got all that set up. I'm like, well, you really shouldn't have us do this unless you've checked with them to make sure this doesn't screw up some kind of estate plan, might screw up taxes, that sort of thing. Okay? Okay, now, what time is it? I don't know. I don't have my watch. 1:37. Okay, I've got a little time. Okay, now I'm going to go through some problems that I see with this, and some of them we've touched base on already, but heirs can be, if we've established that there's not a will, transfer on death deed, and it's definitely going in intestate succession. So what happens is you can file a estate proceeding to establish who the heirs are, or a lot of times it can be done by an affidavit, and these things have different names. I hear different attorneys: affidavit of title, devolution affidavit, affidavit of heirship, but they all do the same thing, transferring decedent's real estate to who the actual heirs are, and not just the heirs, but their percentages, because that can be different. There used to be a small estate section of the code, but it's not really used anymore, hardly ever, because they changed it a few years ago to say that to use that, you have to be either a court-appointed personal rep or court-appointed fiduciary. I was like, well, that does away with the whole idea of using this. So most people will just use one of these affidavits. Does the same thing, really. So now we're talking about intestate succession. Like I said, there's a whole list of, if you die and you have this, it goes to this. If you don't have that, it goes to this, all the way down to cousins and second cousins and things. But where I see a big problem, and this is often, people come in and they think their heirship should be something and it's not. And like I said, heirs are tenants in common, so that their percentage goes to whoever are owned as tenants in common. So one of the things, spouses, I get this a lot. Well, I need to have the property put in my name. It was in my husband's name only, and I need to get it put into my name. And somebody was just talking about that, I think. But sorry, that if it's intestate succession, it doesn't necessarily go to the spouse. And if there are kids, or kids that, even if they're all deceased and they had kids, the wife only gets half. Or if there's no kids, but some of the parents are alive, the spouse has to share, the parents get a fourth. So I've had so many spouses come in, they're, what? This is supposed to be mine, Well, that's not the way the statute's set up. It's really bad, and this causes a lot of trouble. Second, childless spouses. If the person had kids with one spouse and she died, or they got divorced or whatever, and then married somebody else and they never had kids, that spouse gets very little, and mainly most of it goes to the kids. And I won't bore you, the statute's real convoluted how much that spouse gets, but it's not much, I can tell you. And I've had a lot of people come in with that issue. Another problem, kids, they had, it was a blended marriage, and there were 3 kids of the decedent and 3 other kids that he raised as his own and thought of them as his kids. And if those kids weren't adopted, they don't get anything under intestate succession. Now, a lot of times, the other kids will say, well, yeah, those are our brothers and sisters. We want that to be split in 6, but not always. And sometimes that's a real problem. And there's, let's say in this case, there were the 3 kids, and the property would have to go to them, and then they could deed it and make it the way the parties wanted it, even if they weren't adopted. But that's a problem. Most people don't think of that. Or the other way, kids that somebody else adopted, and then that does away with parental rights, so those kids don't get anything. This one's big, and this can be with heirs or devisees. Can't find them, even if they're in prison, or a lot of times we don't know where they're at. We can't find them. Well, we can't help you by doing affidavits, because you're going to need to have them join in. And if you can't find them, you're probably going to have to open an estate to have this taken care of, or you're going to have to hunt them down. It's funny how many times when I say that, they're able to hunt them down, because when they find out that they have to open an estate and go to that expense. And then I see this a lot too, where I've had it to where I've gone through and there's 30 or 40 heirs, different. Some of them have 100th interest, and that one person with 100th interest won't cooperate in a sale. They want more than they're entitled to, or they try to hold the other heirs up. That throws a real brick into it, and then you may have to go back and get an estate open and have it sold out of the estate. Because what happens, let's just say a typical example where dad's dead already, mom owns the property, she had 4 kids. Well, those 4 kids, 2 of them are deceased, and so the 2 that are still alive, they get a 4th, each get a 4th. The 2 that are deceased, their 4th goes to their kids, and I've had it before where they've got 10 kids, so their 4th is divided up into 10ths, and then one of their kids is deceased, but they had kids, so it's a nightmare. But I understand why the legislature did it the way they did, because they really tried, but there's just no way you can account for all these different things that could be the case. And that can be terrible to deal with, and tons of expense. Even if they can get all 40 of them, you have to get 40 different deeds or one deed and send it around to everybody, and it can be a real nightmare and expensive. Another thing, real quick, judgments, tax liens against heirs. Once they become owners, if they have federal tax liens, state tax warrants, or judgments, those liens become a lien. Those matters become a lien on the property, even if they've got 100th interest, and that can be a nightmare trying to get those resolved if they want to sell the property. That's why sometimes when I see that, it's, hey, you got an open estate, and then you can sell the property, and then that person's 100th interest can be available for the creditors. Sometimes the heirs will require will say, well, we're not getting anything done. We'll do a partition action, which basically, court, we have 4 heirs here. We can't agree, so we want you to partition the property. Well, a house can't be partitioned. If it's acreage, sometimes it can be, but a house can't be, so the court will order a sale, and then they'll split up the proceeds, but that's expensive, and a lot of times you don't get the value of what the house should be. Sometimes it's just, I tell them, I don't see any, I think you just let it go into tax sale and try to buy it there if you want it. And that's, I hate that. or don't open an estate and have it sold out of the estate. One thing too that people get confused on is the items that are on the property, the liens, mortgages, tax liens, judgments from the decedent, those, if an heir acquires it, it doesn't get rid of those. Those matters or stay on the property, so if there's a sale, they have to be dealt with. I think I'm running out of time. I better kind of skip through here. I was worried that I was only going to have about 15 minutes of stuff. Another thing that people question me on, the heirs or devisees, you're not liable for those debts of the decedent, personally liable, but the land is. So some people come in and say, well, I don't want anything to do with it. I'm not going to, I do not want to try to pay off that loan, or I do not want to try to pay off those taxes because there's no equity in the property. Or a case like we were talking about earlier where the party who thought they owned it was paying the mortgage and things, and it turns out there's 3 half-brothers that have an ownership interest too, and that can be a real nightmare. So the bottom line, it's so much better to try to deal with these while the decedent's alive, and it's a tough conversation to have, but boy, it sure can. And it's good for the decedent because they can have the property go to where they want it to go. And most of the time, it's not the decedent that doesn't want to talk about it, or the person that's going to be the decedent, the owner. It's the kids. They don't want to talk about mom and dad dying, and I get that. And if you don't have something in place, try to jump on it right after they pass, because with deaths of the heirs, it just multiplies the headache. And like I said, we can always fix, if the family gets along and say, hey, this should have gone to, there's just the one kid. And a lot of times I've had that happen. Well, we'll do this, and then you all just deed to that one kid, and it's simple, easy peasy, okay? The one thing I wanted to say is Annette had sent me a very good article that has probably a lot better than what I just went through, a lot of explanation, and it was from the Federal Home Loan Bank of Indianapolis, and it's, you just go to FHLBI.com, and that'll pull up, and then you hit services, then you hit community programs, then the last thing you hit heirs property, and it was a very good, and it had way more detail than what I went through, and it talked really about the problem in Indianapolis and Fort Wayne, how so many heirs has this problem where the heirs own property, and it's just sitting and going to waste. When you do that, read the article, but then make sure to hit the link, Turning Legacy into Opportunity. And that's right there, and it'll come up as a blue thing. You hit that, and it really goes into a lot of detail. Probably better than rewatching me. You'll probably get a lot more out of it if you go to that. But, now, any questions?
Yeah, what was that change?
Okay, so you go to FHLBI, Federal Home Loan Bank, Indianapolis.com, and then it'll pull up their page, and then there'll be a place called Services. You hit that, then you hit, there's several things under that, Community Programs. Then there's several things under that, and you go to heirs property, and that's where it gets to what we're talking about here. And then once you read that article, in the middle of that article, there's a little connection to another site, and it's called Turning Legacy into Opportunity, and read that as well. I mean, if you're interested in this. Any questions?
Yes.
Well, I'll be devil's advocate. I think it's because, and I've seen this many times, where Timmy will come in and say, my dad wanted me to have this, this should go to me. And then I find out Timmy had 2 brothers and a sister. And when we talk to them, no, that's not what was wanted at all. We should get our share, you know. And either side can be right, but it's to make sure that property gets properly transferred to who really should get it. And I say that, it's not always who should get it by the decedent's wishes if they didn't do what they needed to before they died. It's who the legislature thinks should get it. And they think that outweighs the problems with Timmy coming in saying he should get it all when he really shouldn't.
You read out so much stuff, though, that's why.
Yeah. Well, I think for yours, that transfer on death deed, very simple. If your dad will do it, we'll just put it into whoever he wants, you, your brothers and sisters, the church, whoever he wants to get it. And then if he passes, it's taken care of, and it's not real expensive. Between our fee and the recording fee is just over $100. Anybody else?
So, a lot of times I think, some of the families that we work with, they will say they inherited a property or whatever, not able to take care of it. Is there any official notification somebody needs a property to you, right?
Well, technically, to be a valid deed, you have to accept it. But that's technically. I could deed my house to you and you not know it until you start getting the tax payments from, you know, and you can have it set aside saying, I didn't take that, but I think you'd want my house, maybe, if I gave it to you for free. But where you got to be careful is people come to you and say, I inherited it. I'm not questioning that they don't think they inherited it, because that's what the will says, but they haven't probated the will, so it's not valid, or it's not a valid will, or, you know, or they're the kid, but they didn't realize their stepbrother who was the, you know, adopted, or half brother that was the dad's or mom's issue also got half, you know. That make sense?
Great.
Okay.
Thank you, Jim.
Sure. Well, if anybody has insomnia, they can go watch it on YouTube.
That's a massive lift to come into a space like that, and there's so much there.
Yeah, there's so much, and like I said, I didn't think I had enough, and I could have gone on. I could have rambled on for another hour.